My name is Bill Brush, and I'm the president and founder of Cut Unnecessary Regulatory Burden. The message today in this presentation is to demonstrate how APCO has used the judicial system to intimidate property owners at Smith Mountain Lake since 2001 in order to take our property rights without any compensation. Brief review of some terminology. A third-party non-licensee is a shoreline property owner who has not signed APCO's permits or revocable licenses. A project boundary, we know what that is, but what we may not know is the project boundary doesn't change your property rights. Federal District Court, that's the first level court to hear federal law cases. FERC is given authority to issue licenses to citizens, corporations, states, and municipalities to construct, operate, and maintain dams and reservoirs, hydro projects basically. A FERC licensee is any person, state, or municipality licensed to operate a non-federal hydroelectric project. The FPA, or Federal Power Act, created FERC, granted it regulatory authority over privately owned hydropower projects and their licensees. And State Circuit Court, well, that's the first level state court to hear state law cases. We're going to look at two different strategies or scenarios. The first scenario is where APCO initiates a federal lawsuit. An example of this would be the ongoing Nissen case right now before the Federal District Court in Lynchburg. In order to get this case into federal court, Appalachian had to first violate its FERC-approved SMP and its policy on working with potential violators to notify them in writing of the violation, to notify them what steps need to be taken to correct the violation, and present a timeline for that property owner to comply with APCO's direction. Well, in Nissen's case, none of that happened. They simply violated all of that and filed a preemptive lawsuit in federal district court. In order to keep this case in federal court, Appalachian has to make false claims. False claims being that a property owner violated the Federal Power Act, violated APCO's license, or even its flowage rights. APCO has never cited any specific segment or part of the Federal Power Act or its license that a third-party non-licensee violates. And it's always ignored FERC's rulings and guidance to resolve all property disputes in state court. What's wrong with this is that the Federal Power Act only applies to FERC and its licensees. APCO's license for Smith Mountain only regulates APCO. It regulates no third-party non-licensees. And interpretation of state law deeds and easements are not federal matters. They don't belong in federal court. They are simply matters for state courts. So APCO misrepresented to the federal court that the Federal Power Act and its license granted it authority over private landowners and actually replaces the landowner's state property rights. Well, what's wrong here? Neither the Federal Power Act nor APCO's license applies to a third-party non-licensee, and no license, shoreline management plan, or project boundary changes an owner's property rights. Again, here's what the FERC says about that. It should be noted that the establishment of the project boundary does not have any impact on property rights. So the first thing the property owner does is claim that APCO doesn't have the property rights to regulate his uses. Well, then APCO argues before the court that the court that they filed in really doesn't have jurisdiction to hear this property owner's defense because in reality, in APCO's belief, it's nothing more than a collateral attack on its license and only the FERC has jurisdiction to hear issues of license compliance. What's wrong with this picture? It's illogical that APCO can claim that the property owner violated APCO's property rights, but somehow the property owner can't defend against this claim. FERC can't adjudicate state property rights, and there are matters for state courts to decide. FERC's very clear on this. The Federal Power Act does not confer on this commission jurisdiction or authority to resolve disputes between the licensee and third parties that concern interests in real property. So what's happened here? Appalachian misrepresented to the court that the court had jurisdiction to hear this because a property owner violated the Federal Power Act and its license. It then argues that the property owner can't argue against Appalachian's property rights because that's a collateral attack. The end result of this is the private property owner, the innocent private property owner, now has been denied his right to hear his claims in state court and to defend those claims. Appalachian, through this manipulation of the court system and these legal maneuvers, basically are denying this property owner due process. So now APCO asks the court to determine it has regulatory authority over private property owners. It misleads the federal court, claiming that its license and easement grants it authority over private landowners. Neither do. What's wrong here is APCO's license doesn't apply to non-licensees. APCO's license can't change property rights. In fact, FERC requires APCO to own or purchase or work out an agreement with property owners so that it holds all the necessary property rights to activate and implement its license. So with all these legal maneuvers on the part of Appalachian, it places federal court in the position now to rule on APCO's regulatory authority. What's wrong with this picture is that this case doesn't belong in federal court because federal court doesn't have jurisdiction. There has been no violation of the Federal Power Act. There's been no violation of APCO's license. There's been no violation of any other federal law. District court doesn't have jurisdiction to hear anything about state property rights. That original jurisdiction belongs in state court. But after being maneuvered to hear this case, all that remains now is whether or not APCO's federal license and its property rights give it some power to regulate third-party non-licensees. Well, that's not the case here. In fact, the FERC has said time and time again that state property actions belong in state court, not federal court. What's happened with these maneuvers is APCO has denied the Shoreline property owner access to state court with a preemptive federal filing and by fabricating federal jurisdiction. The court fails to recognize the limits of APCO's license and goes ahead and rules on state property matters, or in some cases has actually ruled that because APCO has a federal license, it has the authority to regulate third-party non-licensees. Bad decisions, wrong decisions, inconsistent decisions. That's why APCO prefers doing business in federal court. On the 2nd of June, a Shoreline property owner at Smith Mountain Lake filed a lawsuit in state court challenging Appalachian's ability to regulate how he uses his property and how he gains access to the waters of Smith Mountain Lake. He claimed that APCO's state property rights and flowage easement are insufficient to regulate uses within the project boundary, and he raised no federal issues. What's right about this is that property rights, according to FERC and the law, are state law matters, and they're best for adjudication in state court. Here's exactly what the commission, the FERC's commission, has stated about that. Any disputes regarding property rights are not within the commission's jurisdiction. Rather, they are matters for state courts to resolve. Well, the first thing APCO does now is remove this case to federal court. As a defendant, it has the right to remove a case originally filed in state court to federal court if there's an overriding federal issue. How does it do that? Well, obviously, it claims that the Federal Power Act gives it federal authority and that its FERC license creates federal jurisdiction. But yet APCO can cite no violation of the Federal Power Act or can justify how its license can remove this case. What's wrong with this picture is that, as we know, the Federal Power Act only applies to FERC and its licensees. APCO's license is a contract between FERC and APCO, and it doesn't reach third-party non-licensees, meaning a third-party non-licensee can't violate the Federal Power Act or APCO's license. It's well known that state law deeds and easements are not federal matters. They're state law matters and under the jurisdiction of state court. But the federal court must accept as true APCO's claim, and the case is removed to federal court. Next, APCO moves to have the case dismissed in federal court because the property owner questioned its license authority and its performance under its license, and says that federal district court can't hear any claims about its license performance, that only FERC can do that. What's wrong here? Well, first of all, the property owner didn't question APCO's license authority. The property owner questioned whether APCO had sufficient state property rights to regulate his use of the project. APCO falsely claimed its federal license granted it authority to regulate non-licensees in its removal action, but it now claims district court has no jurisdiction to hear the case. Wow, what a maneuver. Let's make this whole issue disappear. If the property owner desires, he can do what's called a motion to remand and ask the federal court to send his case back to state court. In January of 2012, Congress changed federal law, and this benefits the property owner because this new law requires the federal judge to separate federal questions from state questions, and any state questions must be remanded back to state court. Perfect. We know that there's no way that a non-licensee can violate the Federal Power Act or APCO's license, so there is no federal question. The only question that remains here is state law. Does APCO have sufficient property rights to regulate a property owner's use of the project? And that's something that should be determined in state court. And now, with this federal change, these cases will be remanded back and those decisions made by state court judges. Again, this law changed in 2012. What's right about this is that federal district court jurisdiction under these cases where a case is initially filed in state court is properly limited to the civil matters concerning the Constitution, federal law, and treaties of the United States. State property rights are not under federal court's original jurisdiction, and this ensures that federal court won't consider those in any ruling. Well, under scenario 2, APCO finds itself back in state court where this whole process started. And now they're going to have to prove to a state court judge operating under Virginia property law that it truly holds sufficient property rights to regulate this property owner's use of the lake. They're going to have to defend why, for 4 decades of common practice, APCO never issued a revocable permit for recreational uses, whether they be commercial or private, never issued permits for vegetation removal or replacement, or for shoreline stabilization. And they're going to have to defend that they haven't expanded their easement rights at the expense of the property owner, effectively denying the property owner access to public waters. Let's wrap this presentation up by summarizing what we've learned. We've learned that APCO has misrepresented regulatory authority to shoreline property owners. We've learned that they've expanded their easement rights to deny property owners access to public waters. We've learned that they've changed 4 decades of common practice where they've never issued a revocable permit for any use within the project boundary. We've learned that they deceived federal court by fabricating federal claims that don't exist. And we've learned that they've been fairly successful extorting private property rights under the claim of federal authority and fear of expensive litigation from property owners by getting property owners to agree to the terms of their permit. Help us defend and save your property rights. We ask you to continue to support C.U.R.B financially so we can continue these efforts to educate and to defend those rights in court. I think after this presentation, you'll see how Appalachian's strategy is starting to unwind, and they will soon find themselves in state court trying to defend why they believe they have property rights and federal authority to steal your property without paying for it. They're not going to be successful.